Hi everyone, welcome back, and today we are going to do a complete session of the public international law with respect to AK and notes. So, topic 1, definition of international law. In modern society, no individual can live outside the society. Similarly, no state can afford to live in isolation in the modern world. International relationship is absolutely necessary in the exigencies of modern world. The present-day world is divided into a number of states. Each state is possessing a system of its own. As these states have different legal, political, economic, and sociological systems, there are chances of conflict between the states in their mutual relationship. In the absence of rules of conduct regulating the relationship of these states, there is very chance of disturbance to the international peace. International law contains a set of rules and regulations which the states have to follow in their mutual intercourse. These rules are intended to set up an orderly and peaceful world. Several authorities have tried to define international law. Some of them are stated below. Professor Oppenheim. Law of nations or international law is the name for the body of customary and conventional rule which are considered legally binding by civilized states in their intercourse with each other. Professor Oppenheim is one of the most celebrated authors of public international law, but his definition suffers from several serious defects. The definition was given in 1905. It might have been good and adequate when it was given. It has now become obsolete and inadequate. And the reasons are: A. The definition says that the rules of international law regulates the intercourse between the states only. The international law in the modern world regulates the relationship not only of the states but also deals with the rights and liabilities of international organizations, non-state entities, and even individuals. Now, reason B. It is now recognized that international law consists not only customary and conventional rules but also of general principles of law such as res judicata, sub judice, subrogation, estoppel, etc. It is because Article 38 of the Statutes of International Court of Justice recognizes general principles of law followed by civilized states as one of the sources of international law. Now, new definition. The editors of the 9th edition of Oppenheim's book, Sir Robert Jennings and Sir Arthur Watts, have revised the definition given by Oppenheim as follows. That is, international law is the body of rules which are legally binding on the states in their intercourse with each other. These rules are primarily those which govern the relation of the states, but states are not the only subjects of the international law. International organizations and to some extent also individuals may be subjects of rights conferred and duties imposed by international law. Another definition by Charles G. Fenwick. International law may be defined as the body of general principles and specific rules which are binding upon the members of international community in their mutual relations. The concept of international community refers to the collection of states, international institutions, individuals, and other non-state entities, such as territories or political units other than states. The definition of Charles G. Fenwick is an appropriate and correct definition of international law. Another definition, that is by J. G. Stark. International law may be defined as the body of law which is composed for its greater part of principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other, and all includes also 1. Rule of law relating to the functioning of international institutions, their relations with each other, and their relations with states and individuals. 2. Certain rules of law relating to individuals and non-state entities so far as rights and duties of such individuals and non-state entities are the concern of the international community. On a consideration of the above stated definitions, we come to the following conclusion. That is, 1. International law is a body of rules and principles which regulate the conduct and relationship of members of international community. 2. International community includes states, international organization, non-state entities, and individuals. 3. The state is not only the subject of international law. International institutions, non-state entities, and individuals are also part of it. and have also come within the purview of the international law. They are also treated as subjects of international law. Now 4. Greater part of the international law is dealing with the conduct and relation of states in their mutual intercourse. 5. International law includes rules of law relating to the constitution and functions of international organizations such as UNO, WHO, IMF, etc. 6. International law regulates the relation between the international institutions, inter se, and their relation with states and individuals. International law deals with the rights and duties of non-state entities such as protectorates and individuals in the international sphere. The next topic we have is the contributions of Hugo Gratius in the development of international law, or Hugo Gratius is considered to be the father of international law. Also, de jure belli et pacis, the law of war and peace. So, international law primarily deals with the conduct and relationship of states in their mutual intercourse. The birth of international law can be tracked back to ancient times. However, the word international law was used for the first time by the eminent British jurist Jeremy Bentham in 1780. Since then, this name has been used to denote the body of rules which regulate the relations among the states. Hugo Gratius, who lived from 1583 to 1645, was a Dutch scholar and diplomat. He was born in Holland on April 10, 1583. At the age of 15, he took the degree of Doctor of Law at the University of Leiden. He has been considered to be the greatest of the early writers of international law. His work, The Law of War and Peace, De Jure Belli et Pacis, 1625, has earned him the title of the father of international law. This book laid the foundation of international law. He is celebrated founder of international law. His contribution to international law can be summed up as follows. 1. He tried to establish that the totality of relation between the states is governed by law. 2. According to him, man is social in nature, endowed with goodness, reason, and morality, and these qualities of man are, in the last analysis, the basis of international law. 3. He advocated that the individuals and the states composed of individuals are identical. 4. He distinguished just and unjust war and contempt unjust war. 5. He argued that a state which is engaged in just war is to be assisted by other states. 6. He urged that the states to settle disputes through negotiations and peaceful means. 7. He advocated that the states should be subjected to the same rules which regulate the individuals. 8. He contended that states violating the law should be punished by other states. 9. Natural law is the basis for determining rules for the rightful conduct of the states. 10. He advocated for the freedom of sea. 11. He formulated the rule that the prisoner of war should be maintained adequately by the capture. 12. He pointed out that the prisoners of war are entitled to their religious rights. And 13. He stated that the diplomatic promises should be immune from search. In other words, the diplomatic promises should be inviolable. The contributions of Hugo Gratius helped to bring a sort of law in the lawless jungle of international relations. His work, De Jure Belli et Pacis, was the first adequate comprehensive book on international law. The next topic is the sources of international law. According to J.G. Stark, the material sources of international law are the actual sources from which an international lawyer determines the rules applicable to a given situation. The material sources of law is different from the formal sources of law. The formal sources of law refer to the legal procedures and methods for the creation of rules of general application. Material sources provide the evidence of the existence of rules of general application. The material sources of international law, which can be referred by an international tribunal for decoding international disputes, may be classified into 6 categories. The first one, international custom. Second, international conventions or treaties. Third, general principles of law recognized by civilized nations. 4. Decisions of judicial or arbitral tribunals. 5. Juristic works. And 6. Decisions or determinations of the organs of international institutions. Article 38 of the Statute of International Court of Justice recognizes only the first 5 sources of international law. The 6th source, that is, decision or determination of the organs of international institutions, does not find mention in Article 38 of the Statute of International Court of Justice. Nevertheless, it has now become a well-recognized source. International custom. International custom is the oldest and original source of international law. The importance of international custom as a source of law has been much diminished in the modern period. However, even today it is regarded as one of the most important sources of international law. Article 38 Clause B of Statute of International Court of Justice recognizes international custom as one of the sources of international law. The customary rules of international law are the rules which have been developed in a long process of historical developments. International custom is the usages or the international habits which have received the force of law. The words custom and usages are used as synonyms. In fact, there is difference between them. Usage is earlier stage of custom. It represents twilight stage of custom. Usage is an international habit of action or rule of action that has not yet received full legal attestation or the force of law. It refers to those habits which are often repeated by the states. When the states in the international relations start behaving in a particular way in certain circumstances, that behavior is called the usage. When this usage receives the general acceptance or recognition of the state in their relations, the usage becomes the custom. A custom is that usage which has obtained the full force of law. A custom is that usage which has obtained the full force of law. Where custom begins, usage ends. When usage crystallizes in itself, it becomes a custom. A customary rule emerges only when it is proved by satisfactory evidence that the alleged rule has been accepted generally by the states. Main ingredients of international custom. A usage will become a custom if the following ingredients are satisfied. 1. Long duration. 2. Uniformity and consistency. 3. Generality of practice. 4. Opinio juris et necessitatis. Opinio juris et necessitatis. So, 4 conditions are to be met if a usage is to become a custom. 1. Long duration. 2. Uniformity and consistency. 3. Generality of practice. And 4. Opinio juris et necessitatis. Now, long duration. The practice of a usage for a long duration is an essential ingredient of a custom in the municipal law. In municipal law, a custom, in order to be valid, is required to be ancient and immemorial. But in international law, a usage need not be practiced for a long period in order to treat it as a custom. In the field of international law, a customary rule may develop in a short period. Rules relating to the sovereignty over airspace is an example of customary rule emerged in a short period. The second condition, uniformity and consistency, and usage can be treated as custom if there is uniformity and consistency. It is to be noted that the complete uniformity is not necessary. There must be substantial uniformity. The third condition is generality of practice. A usage, in order to be treated as a custom, the practice should be observed or repeated by most of the states. If a usage is practiced only by a limited number of states, it will not transform into custom. In the fourth condition, opinio juris et necessitatis. In order to accept a usage as a custom, the most essential ingredient is opinio juris. The states should accept the rules of the practices as binding upon them. In other words, the states should accept the rules of practice as the law applicable to them. West Rand Central Gold Mining Company Limited versus R. 1905. West Rand Central Gold Mining Company Limited versus R. 1905. In this case, the court held that for a valid international custom, the rules of practice should have been received general consent of the states, and civilized states should not have opposed it. Right of passage over Indian territory case. Right of passage over Indian territory case, or State of Portugal versus India 1960. State of Portugal versus India 1960. Right of passage over Indian territory case. In this case, the International Court of Justice pointed out that when a particular practice is followed by two states repeatedly for a long time, it becomes a binding customary rule or local custom applicable to them. Facts of the case: Goa, Daman and Diu, Dadra and Nagar Haveli were three enclaves under the possession and sovereignty of Portugal. As per the Treaty of 1779, the Portugal had a right of passage through Indian territory. Even after India became independent, the right of passage through Indian territory existed. However, the right was subjected to the control and regulations of the Indian government. In 1954, the people of Dadra revolted against the Portuguese government. It resulted in some disturbances over the boundary areas of Indian territory also. The government of India suspended the right of passage. Portugal took this matter to the International Court of Justice. The ICJ held that Portugal was not entitled to send its armed force through the way which fall in the Indian territory. So that is right of passage over Indian territory case, or State of Portugal versus India 1960. Now the third source, international conventions or treaties. The word treaty refers to a document embodying or containing formal contract between the states relating to peace, truce, alliance, etc. International treaties are the most important source of international law in the modern period. Article 38 of Statute of International Court of Justice recognizes international conventions or treaties as the first source of international law. Whenever the International Court has to decide an international dispute, its first endeavor is to find out whether there is an international treaty on the point or not. In case there is an international treaty governing the matter under the dispute, the decision of the court is to be based on the provisions of the treaty. Professor Schwarzenberger defines international treaty as follows. Treaties are agreements between subjects of international law, creating a binding obligation in international law. Now, Professor Oppenheim defines international treaty as follows. International treaties are agreements of a contractual character entered into between the states or organizations of states, creating legal right and obligation. Article 2, Clause 1 of the Vienna Convention on the Law of Treaties 1969, VCLT. Article 2, Clause 1 of the Vienna Convention on the Law of Treaties 1969 defines treaty as follows. An international agreement concluded between states in written form and governed by international law. This definition includes international organizations and thus not a sound definition. This definition excludes international organizations and thus not a sound definition. International treaties may be of two types. They are law-making treaties or treaty contracts. Law-making treaties. Although custom was originally the main source of international law, recently treaties are considered to be the most important and main source of international law. The provisions of law-making treaties are the direct source of international law. Law-making treaties are multilateral treaties. These treaties are entered into by a large number of countries. The law-making treaties lay down general rules binding on majority of states. The United Nations Charter is an example of law-making treaty. The law-making treaties have come into existence increasingly from the middle of 19th century. According to Hudson, there were about 251 law-making treaties during 1864 to 1914, which could be treated as international legislation. The early treaties such as the Peace of the Westphalia 1648, then the Congress of Vienna 1815, the Declaration of Paris 1856, the Geneva Red Cross Convention 1864 are examples of law-making treaties. The importance of law-making treaties in the field of international law can be equated to the legislation in the field of municipal law. The UN Convention on the Law of Seas 1982 and Vienna Convention on Diplomatic Relations 1961 are examples of modern law-making treaties. Now to treaty contracts. Treaty contracts are entered into by two or more states. The provisions for such treaties are not binding on those states who are not parties to it. Treaty contracts are not direct source of international law. The treaty contracts may help the development of international custom. When a similar rule is incorporated in a number of treaty contracts, a new international customary rule may develop. Now, the third source of international law, general principles of law recognized by civilized states. Article 38, Clause 1, Subclause C of Statute of International Court of Justice recognizes the general principles of law recognized by civilized nations as the third source of international law. The expression general principles of law recognized by civilized nations means those principles which have been recognized by municipal law of almost all the countries. Now, the doctrine of res judicata, the doctrine of estoppel, the doctrine of subrogation, etc. are examples of general principles recognized by civilized nations. These principles have received recognition of almost all the states. Chorzo Factory Indemnity Case 1928. Chorzo Factory Indemnity Case 1928. In this case, the Permanent Court of International Justice (PCIJ) applied the principle of res judicata. So, PCIJ existed as a predecessor of ICJ. So, in this case, the principle of res judicata was applied. That is Chorzo Factory Indemnity Case of 1928. Then, Mauromatis Palestine Concession Case 1924. Mauromatis Palestine Concession Case 1924. In this case, the court applied the principle of subrogation. Then, the Temple of Preach Vihar 1962. Temple of Preach Vihar 1962. In this case, the International Court of Justice applied the doctrine of estoppel. Now, Barcelona Traction Case 1964. Barcelona Traction Case 1964. In this case, the International Court of Justice applied the doctrine of estoppel. The ICJ has also recognized the following principles as general principles of law recognized by civilized nations. 1. A party to a dispute cannot himself be an arbitrator or judge. The second one, in any judicial proceeding, the court shall give proper and equal opportunity of hearing to both the parties. So, both of these are based on the natural justice principles. Now, the fourth source, that is decision of judicial or arbitral tribunal, the fourth source of international law. The International Court of Justice is the main international judicial tribunal. The decision of the ICJ does not create any binding general rule of international law. Article 59 of Statute of ICJ makes it clear that the decision of a court will not have binding force except between the parties and in respect of that particular case. Previous decisions of the ICJ are not binding on the court itself. The ICJ is free to deviate from its earlier decision. Thus, the court is not bound to follow the doctrine of stare decisis or precedent. However, in practice, the court ordinarily follows its earlier decision. Now, the fifth source of international law is juristic work. Juristic works cannot be treated as an independent source of law. However, the views of the jurists may help in development of law. According to Article 38 of the Statute of ICJ, the works of the highly qualified jurists are subsidiary means for the determination of the rules of international law. In Paqueta Havana Case 1900, the court held that the fishing vessel and unarmed sailors who who are engaged in their work honestly and peacefully could not be seized during the state of blockade. In order to arrive at this decision, the court relied upon the juristic works. Now, the sixth source of law that is not expressly mentioned in the statute of ICJ but recognized in practice, that is the decision and determination of the organs of international institutions. The statute of ICJ does not recognize decisions and determinations of international organs as a source of international law. Nevertheless, the importance of the decision and determination of international organs as a source of law cannot be ignored. In South West Africa case, the ICJ has taken into account the resolutions of General Assembly condemning apartheid in South Africa. So that is South West Africa case. The next topic is whether international law is law in strict sense of the term, or to the answer to the expression that international law is the vanishing point of jurisprudence, which was stated by Holland. So the views of jurists differ on the question whether international law is law in the strict sense of the term or not. The term law has been defined differently by jurists. The controversy whether international law is law or not revolves around the divergent definitions of the word law given by various jurists. Edward Collins says, whether or not one wishes to attribute a legal character to the norms of international law depends largely upon the definition of law he chooses to accept. The controversy is really logomachy, a dispute about words and not things. A group of prominent jurists kept the view that international law is not law in the strict sense, and a group criticized the view which denies the legal character of the international law, and according to them, international law is really law. The views of both groups of jurists are discussed. The first one, international law is not law. Hobbes, Pfaffendorff, Austin, Holland, Jamie Bentham, and Jethro Brown are prominent jurists who deny the legal character of international law. That is, these are people who say that international law is not really a law. According to them, law is command of the sovereign and is enforced by a superior political authority. Since the law is the command of the determinate superior, no law can exist where there is no supreme lawgiver or coercive enforcement agency. Those jurists who deny the legal character of international law regard law as the command of the sovereignty having a coercive enforcement agency. The rule of the international law cannot be treated as law. The rule of international law can at the most be treated as rules of positive morality. They suggest the following arguments in the support of their views. 1. In municipal law, there is a determinate superior political authority which does not exist in international law. Second, international law lacks an effective legislative machinery. The third, international law lacks sanction, which is an essential element of law. Fourth, there is no executive power in international law to enforce decisions of International Court of Justice and ensure the observance of provisions of treaties. And the fifth one, international law lacks a potent judiciary. Now, Holland has remarked that international law is vanishing point of jurisprudence. In his view, rules of international law are followed by courtesy and hence they should not be kept in the category of law. According to him, rules of international law lack sanction, which is an essential element of municipal law, and thus the rules of international law is the vanishing point of jurisprudence. Now, Justice V.R. Krishna Iyer has also remarked, it is a sad truism that international law is still the vanishing point of jurisprudence. Now, in the case that is Quinn versus Kane, 1878, the court observed that the international law is not really a law, and this was by Justice Lord Coleridge. Law implies a lawgiver and a tribunal capable of enforcing it and coercing its transgressors. In international law, there is no common lawgiver and no tribunal has power to bind the states by decrees or coerce them if they transgress. Now, the second group of thought, or the second group of jurists who believe that international law is really a law. So here Professor Oppenheim, H.L.A. Hart, J.L. Brierley, Sir Frederick Pollock and J.G. Stark are jurists who keep the view that international law is really law. According to Professor Oppenheim, it is wrong to deny the legal character of international law. He defined law as follows. Law is a body of rules for human conduct within a community which by common consent of this community shall be enforced by external power. According to Sir Frederick Pollock, the essential conditions for the existence of law are the existence of a political community and the recognition by its members of the settled rules binding upon them. In that capacity, international law seems to satisfy these conditions. Thus, according to the jurists who keep the view that international law is really law, the existence of law presupposes the following essentials. That is 1. A community, 2. A body of rules, and 3. Common consent of the community for the enforcement of these rules by external power. The above stated 3 requirements of law are satisfied by international law. In the present day world, there exists a community of nations. There exist rules of conduct which have been grown up for hundreds of years as a result of custom and treaties. There is common consent of community of nations for the enforcement of external power. The argument of jurists who regard international law as really law may be summed up as follows. 1. The term law cannot be limited to rules of conduct enacted by sovereign authority. In primitive society, there was no sovereign political authority, yet there was law. The common law of England is not made by any sovereign political authority. Thus, even though there is no sovereign political authority, there may exist law. The second, the bulk of international law comprises of rules laid down by various lawmaking treaties. The rules laid down by these treaties are binding, although they do not emanate from a sovereign political authority. Third, there is an international court of justice to decide disputes which are submitted to it. It has to decide disputes as per international law. The fourth one, the decisions of International Court of Justice are binding upon the parties to the dispute. As per Article 94 of the UN Charter, each member of the UN has to comply with the decision of ICJ. If any party to a case fails to perform the obligations incumbent upon it under a judgment of ICJ, the other party may approach the Security Council and it will decide upon the measure to be taken to give effect to the judgment. On the basis of these arguments, it may be concluded that international law is really law. However, it has to be admitted that international law is not equivalent to municipal law. Even now, there is no world legislature and no international court with compulsory jurisdiction. J.G. Stark has expressed the view that international law is a weak law, but despite the weakness of international law, the legal character cannot be denied. It may be concluded that international law is in fact law, and it is wrong to say that it is the vanishing point of jurisprudence. The next topic is international law is a weak law, and state the causes for its weakness and suggest the method to improve it. So, international law is said to be a weak law, and the following are the causes of its weakness. We have discussed 6 causes. First one, it lacks an effective executive authority to enforce its rules. Second, it lacks an effective legislative machinery. Third, the ICJ lacks compulsory jurisdiction. The fourth, the rules of international law are being frequently violated because of ineffective sanction. 5. The enforcement machinery of international law is very weak. 6. The rules of international law suffer from uncertainty. Now, the suggestions for improving international law. 1. The ICJ should be given compulsory jurisdiction. 2. An international criminal court should be established to adjudicate cases relating to international crimes. Third, international law should be properly codified. 4. The machinery to enforce decisions of ICJ should be strengthened. 5. An international police system should be established to check international crimes and to enforce the rules and principles of international law. 6. An international bureau of investigation and prosecution should be established for investigation of international crimes and the prosecution of international crimes. And 7. The powers and scope of the activities of the International Law Commission should be expanded. The next topic we have is relationship between international law and municipal law, or discuss the theories of monism and dualism, or discuss various theories with regard to the relationship between international law and municipal law and state practices. So, in order to explain the relationship between international law and municipal law, various theories have been propounded by jurists, following as some of the prominent theories in this connection. The first one is monism. Wright, Kelsen, Duguid are some of the prominent exponents of monism. According to the exponents of monistic theory, law is a unified branch of knowledge. According to this theory, international law and state law are the components of one system of law in general. In view of monistic writers, international law and municipal law are intimately connected with one another or each other. There are two branches of unified knowledge of law. Both are applicable to human community. In the ultimate analysis of law, man is at the root to all laws. All laws are made for men. In the case of international law, it regulates the human conduct through the medium of state. A state is made for the human beings and human beings are not for the state. The other theory is dualism. The chief exponents of this theory are Trippel and Ancelotti. In the view of the dualistic writers, international law and state law are two separate laws and there is no relationship between these two. Trippel has pointed out the following differences. 1. Individual is the subject of state law, whereas states are the subject of international law. Second, the origin of state law is the will of the state, whereas the origin of international law is the common will of the states. Further, Ancelotti has tried to explain the differences between international law and state law in a different way. According to him, there is a difference between the fundamental principles of international law and state. The fundamental principles of state law is that the laws enacted by the competent legislative authorities are to be obeyed. The fundamental principles of international law is pacta sunt servanda, which means agreements between the states are to be followed in good faith. According to dualistic theory, international law and state law are two legal systems which are entirely different for three reasons. They are: 1. They differ as regards their sources. The source of municipal law is the will of the state, whereas the source of international law is the common will of the states. Second, they differ regarding the subject they regulate. Municipal law regulates the relationship between individuals, whereas international law regulates relation between states. Third, these two legal systems differ regarding the sanction. Municipal law has a strong sanction, whereas international law has a weaker sanction. Now, there is criticism to this these theories. So, monism is a very sound theory, but in practice, states do not follow this theory. A sovereign state is not absolutely bound by international law. State follows international law simply because they give consent. An individual in the state may not be punished for violation of international law. The dualistic theory is also not absolutely correct. The truth lies somewhere between these two conflicting theories. Now, state practices regarding the relationship between international law and municipal law. So first, British practice. British practice regarding the application of customary and treaty rules of international law in the municipal field can be studied under two heads. And the first one is British practice in regard to customary rules, and the second one, British practice with regard to treaty rules. So, British practice in regard to customary rules. In Great Britain, customary rules of international law are treated as part of British laws. British courts treat customary rules of international law as part of their own law. However, the rules of international law should not be inconsistent with the British statutes and decisions of the highest court of England. If the highest court of Britain once determines the scope of a customary rule of international law, then all courts in Britain are bound to follow it, even though subsequently a different customary rule of international law develops. So, Chung Chi Chong versus R, that is C-H-U-N-G, Chung, C-H-U-N-G, Chung, Chi, C-H-I, then Chong, C-H-U-N-G, Chung Chi Chong versus R, 1939. In this case, Lord Atkin laid down the law regarding the relationship between customary international law and English municipal law. According to him, the rules of international law must be treated to have been incorporated into the domestic law so far as the rules of customary international law are not inconsistent with rules enacted by statutes or finally declared by highest court. Now, British practice with regard to treaty rules. In Britain, the practice regarding the rule laid down by treaties are different from the practice in regard to the customary rule of international law. As far as treaty rules are concerned, the British practice is that the courts will not apply such rules automatically in the municipal sphere unless specifically adopted or transformed into an act of the Parliament. For example, specific adoption theory or transformation theory. This can be referred to as specific adoption theory or transformation theory. So that is with respect to treaty rules. Now, the following kind of treaties require an Act of Parliament to be operative in England. The first one, treaties which affect the rights of British citizens. The second, treaties which amend or modify common law or statute law of Britain. Third, treaties which confer additional power on Crown. Fourth, treaties which impose additional financial burden on the government. And the fifth, treaties involving cession of British territory. If the treaty rules are in conflict with the law enacted by the Parliament, such rules of international law will not be applied by the British courts unless Parliament makes necessary amendments in their law so as to avoid the conflict. Then we have the American practice. So with respect to the American practice, A. Customary rules. In America, customary rules of international law are treated as part of American law. The American practice regarding customary rules of international law is more or less same as British practice. Here, Paqueta Havana case 1900. In this case, the court held that the customary rules of international law is part of American law. B. Treaty rules. American practice regarding rules laid down by the treaties is different from the British practice. In America, treaty rules of international law has been classified into two heads. First, self-executing treaties, and the second one, non-self-executing treaties. Self-executing treaties are not against the American Constitution, and those treaties are applicable in America without any act of the Congress. In case of non-self-executing treaties, which are against the American Constitution, they are applicable in America only after its adoption by specific statute. And then we have the Indian practice. So with respect to customary rules, in India, customary rules of international law are treated as part of Indian law if they are not inconsistent with the Constitution or any other legislative enactment. With respect to treaty rules, as regards treaty rules, India also follows more or less the British practice. Ordinarily, international treaty law becomes a part of municipal law of India only if it has been specifically incorporated. That is specific adoption theory or transformation theory. Now, Jolly George Verghese versus Bank of Cochin 1980. Jolly George Verghese versus Bank of Cochin 1980. In this case, the Supreme Court held that the international conventional law must go through the process of transformation into the municipal law before the international treaty can become an internal law or municipal law. In another case, that is
Gramophone Company of India Limited versus Birendra Bahadur Pandey. That is 1989. So Gramophone Company of India Limited versus Birendra Bahadur Pandey, 1989. In this case, the Supreme Court held that if in respect of international law, the Parliament says no, the National Court cannot say yes. The National Court shall approve the international law only when it does not conflict with the national law or municipal law.
The next topic we have is subjects of international law, or states are the only subjects of international law, or discuss the status of individuals and international organizations under international law. Now, a subject of law is a being upon which the rules confer rights and imposes duties. So, a subject of law is a being upon which the rules confer rights and impose duties. According to traditional view, international law deals with the rights and duties of states. One who examines the definitions of international law given by various jurists in 19th century would come to a conclusion that law of nations or international law is only dealing with rights and duties of states. According to Professor Oppenheim, law of nations or international law is the name of body of customary and conventional rules binding upon the states in their intercourse with each other. It is true that international law was primarily concerned with rights and duties of states, but in the modern context, international law deals with the rights and duties of states, international organizations, non-state entities, and even individuals. The editors of Oppenheim's book, Sir Robert Jennings and Arthur Watt, have raised the definition given by Oppenheim. According to them, international law primarily governs the relation of states, but states are not the only subjects of international law. International organizations and individuals may be subjects of rights conferred and duties imposed by international law. The view of editors of Oppenheim's book is correct in the modern context. It is almost similar to the view of J.G. Stark and Fenwick. The view of J.G. Stark is the international law contains three set of rules. These are 1. Rules regulating the relation between states. 2. Rules regarding the structure and function of international organizations and their relations with each other and state and individuals. 3rd, rules relating to individuals and non-state entities such as colonies and protectorates. The question who are all subjects of international law has been answered by different jurists differently. As a result of divergent views of jurists, three theories arise. They are 1. States are the only subject of international law. The second theory, individuals alone are the subjects of international law. And the third theory, states are the only subjects of international law, but to a lesser extent, international organizations, individuals, and non-state entities are also subject to international law. Now, the first theory, states are the only subjects of international law. Jurists like Professor Oppenheim, Gray, and J.L. Brierley have expressed the view that states are the only subjects of international law. In their view, international law regulates the conduct of states and states alone are the subjects of international law. The above stated view has been criticized by some jurists. The following are the criticisms. A. This theory failed to explain the case of slaves and pirate under international law. International law confers some right upon the slaves and imposes liability on pirates. Pirates are treated as enemies of mankind. They may be punished for the offense of piracy by any state which apprehend them. B. War criminals can be punished under the international law. The Nuremberg and Tokyo trials of war criminals after the Second World War established the principle that international law regulates the conduct of individuals. The Nuremberg trial, several Nazi leaders were hanged to death and some of them were imprisoned. In the Tokyo trial, Japanese war criminals were tried and convicted. Now the C. According to international law, each state is under a duty to protect the foreigners in their territory as if its own citizen. D. In the case of reparations for injuries suffered in service of UN, that is 1949, the ICJ held that UN has the capacity to bring an international claim against the state when an agent of the UN suffers injury in the performance of their duties. Thus, the traditional view of the state are the only subjects of international law is not correct. So, there are mainly four criticisms to the first theory, that is, the states are the only subjects of international law. The second theory is that individuals alone are the subjects of international law. Jurists like Westlake and Kelsen give the view that in the ultimate analysis of international law, only individuals are the subject of the international law. According to Westlake, the rights and duties of the states are only the rights and duties of men who compose them. Views of Kelsen and Westlake appear to be logically sound, but in actual practice of the states, it is seen that the primary concern of international law is with the rights and duties of the states. Now, the third theory, that is, states are the main subjects of international law, but to a lesser extent, international organizations, individuals, and non-state entities are also the subjects of international law. So, that is the third theory. The third view is that the states, individuals, international organizations, and non-state entities are subjects of international law. This view is better than the first and second views. In order to substantiate this view, the following arguments are noteworthy. There are 6 arguments put forth. The first one, several treaties entered into by the states have conferred individuals certain rights and duties. International conventions on human rights, international conventions on apartheid in sports are examples of such treaties which confers rights on individuals. The second one, the Dan Swing Railway official case, that is in 1928. The Permanent Court of International Justice held that if in any treaty the intention of the parties are to confer any right upon some individuals, the international law will recognize such rights and will enforce them. In this case, Poland had acquired Dan Swing Railway Company under an international agreement. The treaty provided that the officers of the railway company would be given certain facilities and benefits. Subsequently, Poland refused to provide those facilities and benefits to the officials of the company. The Permanent Court of International Justice held that if the states in their treaty confer certain rights and benefits to the individuals, the international law will recognize such rights and enforce them. Now, the third one, that is in Geneva Convention on the Prisoners of War, that is in 1949. Geneva Convention on the Prisoners of War, it had conferred certain rights on prisoners of war. The fourth one, the Genocide Convention, that is in 1940, had imposed certain duties directly upon the individuals. According to the convention, persons guilty of genocide may be punished even though the person committed genocide is an ordinary individual. So, and the fifth one is the Nuremberg and Tokyo trials. It established beyond doubt that war criminals could be punished under international law. Then, the sixth one, the decision of ICJ in case of reparation for injuries suffered in the service of UN, that is in 1949, established beyond doubt that international organs are also subjects of international law. In short, the view that the states, international organizations, non-state entities, and individuals are the subject of international law is more appropriate and correct. The next topic we have is state. States are the primary subject of international law. A state may be defined as a society of men occupying a territory, the members of which are bound together by the tie of common subjection to a government and which has capacity to enter relations with other entities. Montevideo Convention on the Rights and Duties of States of 1933. Montevideo Convention on the Rights and Duties of States 1933 laid down that the state as a person of international law should possess the following qualification. That is 1. A permanent population, 2. A defined territory, 3. A government, 4. Capacity to enter into relation with other states. Population. A territory where people have not settled down would not be regarded as state. Now, defined territory. A state must have a defined territory. A state should have possession and control over a territory. Government. The people and the territory should be governed by a government.
In a territory, if there is no government, it is not a state. Now, capacity to enter into relation with other state. A state must have the capacity to enter into relation with other state. Now, there are different kinds of states. The first one, sovereign state. A sovereign state is one which is internally and externally independent. And internal matters and external affairs, the sovereign state is independent and it will have supreme and absolute power. A sovereign state is free to adapt or adopt any constitution it likes, arrange its administration in any way it thinks fit, enact such laws as it pleases, adopt any commercial policy it likes, and so on. A sovereign state is free to frame its foreign policy. It can establish relation with other states. No other state can prescribe the rules of conduct which a sovereign state should follow in international affairs. In the modern world, a sovereign state does not possess supreme and absolute powers. A sovereign state is bound by the rules of international law. Supreme and absolute powers of the sovereign state are further qualified by the principles of good neighborliness. The principle of good neighborliness says that a state shall not use its territory for purpose injurious to the interest of other states. If the acts of a state causes injury to another state, the former state shall be responsible for injury caused to the latter state. A sovereign state, though is independent and can use its territory for any purpose, it should not permit its territory for purpose injurious to another state. Under international law, a state is under a duty to prevent its territory from being a source of economic injury to neighboring states. Now, trial smelter arbitration case, that is US versus Canada in 1941. Trial smelter arbitration case, US versus Canada, 1941. This case related to the damage caused to the state of Washington by fumes of sulfur dioxide emitted from its trial smelter on the Canadian territory. The SO2, that is sulfur dioxide, fumes caused damage to agriculture in Washington and they claimed compensation. The tribunal held that no state has the right to use or permit the use of its territory in such a manner as to cause injury to the territory of another state or the properties of a person in another state. Principles 21 and 22 of the Stockholm Declaration on Human Environment of 1972 declares that a state shall be responsible if it causes damages to the environment of other states or of areas beyond the limits of national jurisdiction. Under the international law, all sovereign states are equal in status irrespective of their size, population, and resource. The UN Charter is based on the principle of sovereign equality of the states. Now, federal state. So, that was with foreign state, next sovereign state, and next we are going to discuss about federal state. A federal state is formed by the merger of two or more than two sovereign states. Under international law, a federal state is an international person. In a federal state, the powers of central government and uniting states will be divided by a constitution. United States of America, Switzerland, and India are good examples of federal states. The third kind of state is protectorate state. A protectorate state, by a formal treaty, places itself under the protection of a stronger state. A protectorate state entrusts its matters of security, defense, and external affairs to another state. The protectorate state surrenders to the stronger state the administration of important international affairs. A protectorate state is not an absolutely sovereign state. Nevertheless, a protectorate state can become a member of UNO. In internal matters, a protectorate state is free to adopt any policy as it pleases. Bhutan became a protectorate of India through a treaty of friendship concluded on August 8, 1949. So, Bhutan is a protectorate of India and it is through a treaty of friendship that concluded on August 8, 1949. In 1971, Bhutan was admitted to the United Nations with full support of India. Sikkim became a protectorate of India through a treaty concluded on December 5, 1950. whereby India assumed the responsibility of the Sikkim's external affairs, communications, defense, and territorial integrity. The Indian protectorate over Sikkim terminated in 1974 when Sikkim became an associated state of India. Now, the fourth kind of state is vassal state. A vassal state, a state which is under the absolute control in external affairs of another state, is called a vassal state or vassal state. Now, a vassal state does not have capacity to enter into relationship with other state. All international treaties concluded by the suzerain state or ipso facto concluded for the vassal state, if exception is not expressly mentioned. War of suzerain is ipso facto war of the vassal. A vassal state is free to regulate its internal matters. In 1951, Dalai Lama, on behalf of the Tibet, entered into a treaty with China, wherein Dalai Lama was recognized by China as a spiritual temporal ruler of Tibet, subject to the Chinese suzerainty. By the terms of the treaty, in the internal affairs, Tibet became autonomous, and in the external affairs, Tibet was under the suzerainty of China. Thus, by this treaty, Tibet became a vassal state. But China violated the treaty by making interference in the internal affairs. In 1959, the situation had worsened so much because of the suppression of the people's movement by China. Dalai Lama had to flee from Tibet. He took asylum in India. Since then, China exercises full control in the internal and external matters of Tibet. Thus, now Tibet is not a vassal state. Tibet has no international status. The position of vassal state is different from the protectorate state. The following are the difference. In case of the vassal state, suzerain power absorbs foreign relations entirely. In case of protectorate, the superior power protects the weak in accordance with the terms of treaty. The second one, if war is declared by the suzerain power, it will ipso facto become war of the vassal state. If war is declared by the protecting state, it will not ipso facto become war of the protectorate state. The third one, an international treaty concluded by suzerain power will ipso facto bind the vassal state. In case of the protectorate state, a treaty concluded by protecting state will not bind the protectorate state. The fourth one, a vassal state cannot become a member of the international organization including UNO. A protectorate state can become a member of the international organization. Now, the fifth kind of state is Holy See or Vatican City. The Holy See is a small sovereign state having land territory of about half square kilometer and population of about 1,000, composed of persons residing therein by virtue of their office. The head of the Catholic Christian Pope is the monarch of the Holy See. The Holy See possesses an international personality despite being a very small state. Vatican City is fully independent and sovereign state under international law. It is not a member of UNO. So that is with state and different kinds of state. The next topic is recognition of states or constitutive theory of recognition and declaratory theory of recognition, or de facto recognition and de jure recognition. So there are two theories or two kinds, that is constitutive theory and declaratory theory, or de facto recognition or de jure recognition. So state is the main subject of international law. Recognition of a state is an act by which an existing state acknowledges that the political entity which is recognized possesses all the essentials of statehood. The essentials of the statehood are four, as discussed earlier, that is permanent population, definite territory, a government, and capacity to enter into relations with other state. According to Professor Oppenheim, in recognizing a state as member of international community, the existing state declare that, in their opinion, the new state fulfills the conditions of statehood proposed by international law. According to Fenwick, recognition is an act by which the members of international community formally acknowledge that the new state has acquired international personality. The Institute of International Law has been defined the term recognition as follows. It is the free act by which one or more states acknowledge the existence of a definite territory of a human society politically organized and capable of observing obligations of international law. It is an act by which the existing states manifest their intention to consider the new state as member of international community. Now, the theories of recognition. We have two theories of recognition, that is constitutive theory and declaratory theory. So, constitutive theory. Hegel, Ancelotti and Oppenheim are the chief exponents of constitutive theory. According to this theory, a state comes into existence only when established states recognize it. Holland also supports the constitutive theory. In this view, recognition confers maturity upon states. This theory states that a state acquires rights and duties under international law only when the existing state recognizes it. Advocates of this theory hold the view that recognition is a process through which a political community acquires international personality by becoming a member of family of nations. According to this theory, if a state is not recognized by other states, it will have neither duties nor rights under international law. This is a very absurd suggestion. If we accept the constitutive theory as correct, it will create a difficulty to create a new state which is recognized by some states but not recognized by others. The example of China and Bangladesh can be cited in this connection. China was not recognized by America and some Western countries for a number of years, although China possessed all the essentials of a state. During the period when China was not recognized by some states, it had rights and duties under international law. Bangladesh was not recognized for some time by China, Pakistan and Albania. If we assert that Bangladesh did not have rights and duties under international law during that period, it would be an absurd proposition. Thus, constitutive theory is not a sound theory. The second theory is declaratory theory. The chief exponents of this theory are Hall, Wagner, Rarely, Bitt, Corbett and Fisher. According to this theory, state exists even though there is no recognition. Recognition is only a formal acknowledgement through which the existing states accept the established fact. The act of recognition is only a declaration of an existing fact that a particular state possesses all the essentials as required under the international law. Now, with respect to modes of recognition, there are two modes of recognition, that is de facto recognition and de jure recognition. So, de facto recognition. The practice of states showed that in the first stage, the states give de facto recognition to a new state or new government. When the recognized state feels that the state which has received a de facto recognition is capable of fulfilling international obligation, de jure recognition will be conferred. According to Professor Schwarzenberg, when a state wants to delay the de jure recognition of a new state, it will grant de facto recognition in the first stage because the state which is giving recognition doubts the state recognized may not be stable. Now, de facto recognition means that the state recognized possesses the essential elements of statehood, but its stability is doubtful. Under de facto recognition, diplomatic relations are not established. De facto recognition is provincial. In the case of de facto recognition, the recognition state establishing its relation with recognized state without establishing diplomatic relations. The second mode is de jure recognition. De jure recognition is final and permanent. It is granted when the recognized states possess all the essential requirements of statehood and is capable of fulfilling obligations under international law. The British practice showed that three conditions are required for granting de jure recognition to a new state or a new government. They are: 1. the government should have the general support of the population. Second, there should be reasonable assurance of stability. Third, the government should be able and willing to fulfill its internal obligations. De jure recognition is final, and once given, it cannot be withdrawn. De jure recognition results from an express declaration indicating clearly the intention to grant the recognition by establishing diplomatic relations. Now, the distinction between de facto and de jure recognition. We can broadly classify them into three. The first one, de jure recognition is final and permanent. De facto recognition is provincial and is liable to be withdrawn. The second one, when granting de facto recognition, there will be no diplomatic relations. When granting de jure recognition, there will be diplomatic relation. The third one, only the de jure recognized state or government can claim to receive property situated in the territory of the recognizing state. When there is a conflict claim, the claim of the de jure recognized government will prevail over the claim of de facto government. This principle was established by the decision in Emperor Haile Selassie vs. Cable and Wireless Limited in 1938. That is Emperor Haile Selassie vs. Cable and Wireless Limited 1938. In this case, the Cable and Wireless Limited had entered into a contract in 1935 with the Director of Post, Telegraph and Telephone of Ethiopia and was running a radio telegraphic service between Great Britain and Ethiopia. The company owed some amount to the government of Ethiopia. At that time, Italy conquered Ethiopia. Haile Selassie, the Emperor of Ethiopia, went in exile to England. While there, the Emperor filed a suit against the company for the realization of money due to the government of Ethiopia. At the time of institution of the suit, the British government recognized Italian government as the de facto government of Ethiopia and Haile Selassie as the de jure emperor of Ethiopia. The company admitted that the amount was due to the government of Ethiopia, but it contended that it had received a letter from Italian ambassador in London that the amount due should be paid to the Italian government and not to the emperor. But Justice Bennett held that the title to sue for the debt was vested in Haile Selassie as the de jure emperor of Ethiopia. The company preferred an appeal against the decision. While the appeal was pending, the British government recognized Italian government as the de jure government of Ethiopia. The Court of Appeal held that as the British government started to recognize the Italian government as de jure government of Ethiopia, the right to sue for the debt due to the government was passed to the de jure government and the suit instituted by Haile Selassie was dismissed and the appeal was allowed. Now, the fourth distinction is that when there is a conflict of law enacted by de jure government and de facto government, the English court will recognize only the laws enacted by the de facto government as legally binding. So, the above said principle has been recognized by the decision in Bank of Ethiopia versus National Bank of Egypt and Liguori. So, the right to sue is with de jure government, and when it is about the enactment of law, that is with the de facto government. So, with respect to that, the cases Bank of Ethiopia versus National Bank of Egypt and Liguori. Italy conquered Abyssinia in 1936. The British government recognized Italian government as the de facto government of Abyssinia, and emperor who was in exile was regarded as the de jure sovereign of Abyssinia. The government of Italy enacted some laws for Abyssinia. The laws were in conflict with the laws of emperor who was in exile. The question before the court was which law is to be recognized as legally binding. The court held that the authority of de jure ruler was merely theoretical and was not capable of being enforced. Thus, when there is a conflict between the laws enacted by the de facto government and de jure government, which has no control over the territory, the English court will recognize only the laws of de facto government as legal and binding. Now, the fifth distinction between de facto and de jure government, that is, A de facto government can also claim immunity from legal process as in the case of de jure government. So both can claim immunity. Now, Aranzazu Menti. The case is Aranzazu Menti. Here, during Spanish Civil Wars, that is during 1936 to 1938, during Spanish Civil Wars, insurgents led by General Franco occupied greater part of the Spanish territory. British government recognized nationalist government under the General Franco as the de facto government, and at the same time the Republican government as de jure government. The Aranzazu Menti was a private-owned Spanish ship registered at Bilbao. After the occupation of Bilbao by insurgents, that is the national government, the Republic government, who is the de jure government, issued a decree taking the Aranzazu Menti in its possession. At this time, the ship was in high seas. When the ship reached London, the owner of the ship obtained a writ for taking possession of the ship. This ship was arrested by the Admiralty Marshal. Thereafter, the nationalist government, led by General Franco, issued a decree taking the said ship and other ships in his possession. The nationalist government claimed immunity from the jurisdiction of the English court and argued that the English court has no jurisdiction to decide the dispute. The House of Lords held that the de facto government was entitled to immunity from the jurisdiction of English court and declared the warrant of arrest as invalid. Now, legal effects of recognition. The following are the main legal effects of recognition. There is mainly four. The first one, the recognized state becomes entitled to sue in the courts of recognizing states. Second, the courts of the recognizing states give effect to the legislative and the executive acts of the recognized states. The third, the recognized state can claim diplomatic and proprietary immunity in the recognizing state. The fourth one, the diplomatic envoys of the recognized state will get a number of privileges and immunities in the recognizing state. Now, with respect to consequence of non-recognition, the following are the consequences of non-recognition, which are mainly four. The first one, a non-recognized state cannot sue in the court of the state which has not conferred recognition. The second, a non-recognized state can neither establish diplomatic relation nor enter into treaties with the states which have not recognized it. The third, diplomatic representations of a non-recognized state do not possess privileges and immunities in the states which have not recognized it. Fourth, a non-recognized state is not entitled to claim its properties situated in the state which has not recognized it. Now, retroactive effects of recognition. As a general rule, states will first confer de facto recognition to a new state. If the de facto recognized state shows its stability, de jure recognition will be granted. De jure recognition is said to have retroactive effect. That means once de jure recognition is granted, it would be treated that there was de jure recognition even from the date on which de facto recognition was granted. So that is with the retroactive effect of recognition. So, Civil Air Transport Incorporated versus Central Air Transport Corporation, that is CATI, Civil Air Transport Incorporated versus CATC, Central Air Transport Corporation. That is a case in 1955. In this case, Privy Council held that even though de jure recognition will have retrospective effect to validate the acts of de facto government, the retrospective effect will not have force to invalidate acts of the previous de jure government. So, the retrospective effect will not have the force to invalidate acts of the previous de jure government. So, to the facts of the case, 40 aircrafts belonging to the government of Republic of China, that is the nationalist government, de facto government, were lying on airfield in Hong Kong, a British possession. The CATC was administrating the state-owned commercial air force. Subsequently, the People's Government of China, that is the Communist government, declared itself to be the government of China. The Communist government declared CATC to be their property. After 1 month, the Nationalist government sold the 40 aircraft to the CATI, which was an American partnership. At the time, the government of UK recognized national government as the de jure government of China and communist government as the de facto government of China. After a month, the government of UK ceased to recognize the nationalist government and recognized the communist government as the de jure government of China. The question before the court was that whether the retrospective operation of de jure recognition of communist government invalidated the transfer of aircraft by nationalist government. At the time of the transfer, the nationalist government was recognized to be the de jure government of China. The court held that conferring of de jure recognition, though has retrospective operation, it cannot operate in such a way as to invalidate the acts of de jure government at the time of transfer. So that is with recognition of a state, the two theories of recognition and the two modes of recognition. The next topic we have is state succession. According to Oppenheim, succession of international person or state occurs when one international person takes place of another international person in consequence of certain changes in the latter's condition. When one international person or state takes the place of another state, rights and liabilities pass on to such state, and that is called state succession. The law of state succession is not yet developed. When one state takes the place of another state, the question of succession of rights and duties to the new state would arise. The succession of rights and obligations to a new state depends upon various circumstances and types of succession. So mainly there are two kinds of state succession, that is universal succession and partial succession. Universal succession. Universal succession takes place under the following circumstance: when a state is completely merged with another state, or when a state breaks into several parts and each part becomes a separate international person. So these are the two circumstances where universal succession takes place. Now we have partial succession. When a part of the state revolts and after achieving freedom becomes a separate international person, the breaking away, such as the breaking away of Bangladesh from Pakistan and becoming a separate international person, is an example of partial succession. Or when a part of the state is ceded to another state, that is partial succession. Now, rights and duties arising out of state succession. The first one, political rights and duties. No succession takes place in respect of political rights and duties, and hence the succeeding state is not bound to follow the principles of political treaties for the former state. Then the second is state property. Property of the extinct state will succeed to the new state. The third one, state debts. If the successor state is a newly independent state, it will be bound by the debts of the predecessor state only if the new state has benefited from the loan. If the debt has been incurred for a purpose hostile to the successor state or for the benefit of some other state, then there is no obligation in international law which binds the successor state to pay it. So that is with state debts. Now the fourth one is succession of contractual rights and obligation. The general rule is that succeeding states would not be bound by the contracts entered into by the extinct state unless the succeeding state accept the contractual obligation. So we have case law here, that is Western Central Gold Mining Company Limited versus King, that is in 1905. The Western Gold Mining Company was a company registered in England. It was engaged in the work of digging of gold mines in Transylvania. Now in October, gold mines in Transvaal. In October 1899, 2 parcels containing gold were seized by the officers of the South African Republic. As per the terms of the contract, it was the responsibility of the South African Republic to return the said parcels of the gold or equivalent money in lieu of the parcel. Meanwhile, war broke out between Britain and South African Republic, and the latter was conquered by Britain on October 11, 1899. The company filed a petition claiming gold bar or its value from the British government. It was held that the succeeding state is entitled to decide whether it will accept the contractual obligation of the former state. Until it accepts the contractual obligation of the former state, it will not bind the new state. So that was in West Rand Central Gold Mining Company Limited versus King in 1905. Now the fifth point, with regards to the rights and duties arising out of state succession, the fifth point is succession of concessionary contracts. Concessionary contracts such as digging of mines, license to carry on a particular business, etc., which are entered into by the extinct state will not bind the succeeding state. So we have a case law in that is Premchibar versus Union of India 1960. The petitioner was a citizen of former Portuguese territory. On December 20, 1961, Portuguese territory was merged in India and the petitioner adopted Indian citizenship. About 3 months before merger of Portuguese territory in India, the petitioner had obtained a license for importing goods worth about 10 lakh pounds, and on the basis of the said license, he had even advanced some money. After acquiring Indian citizenship, he requested the government of India to extend the period of license for importing goods. It was rejected by the government of India. He approached the Supreme Court alleging that the decision of the government of India violated his fundamental rights under the Constitution of India. The Supreme Court held that the residents of territories did not carry with them the right which they possessed as subjects of the ex-sovereign. The new sovereign is free to determine whether the period of license is to be extended or not. The Supreme Court dismissed his petition. That was with respect to the rights arising out of concessionary contracts. Now, the sixth one is that succession of liability for tort. The general rule is that the new state is not liable to pay compensation for the tort committed by the former state. If the former state had decided to pay compensation, the succeeding state will be bound by the decision. We have a case law, that is Robert E. Brown claim case, that is in 1925. Here the tribunal held that the successor state is not bound to respect a claim for unliquidated damages in tort. So the facts of the case: Robert E. Brown was an American citizen. In 1894, he went to South Africa and started the work of digging gold mines after obtaining license. After some time, the head of the state of the South Africa declared that in the eastern part of that area, the state would undertake the work. Robert E. Brown filed a suit for recovery of compensation. While the case was pending in the court, Great Britain conquered South Africa and incorporated it in its empire. The government of America claimed compensation from British government on behalf of Brown. The matter was referred to arbitration. The American and British Claims Arbitration Tribunal held that for the tort committed by a state, the successor state is not bound to respect a claim for unliquidated damages. Now, the seventh point, that is succession regarding membership of the UN. So no succession takes place in respect of the membership of the UN. After the partition of India, Pakistan claimed membership of UN by succession because India was an original member of UN. The General Assembly rejected the claim of Pakistan. Subsequently, Pakistan applied for the membership and was admitted as a new member. So that is with the effects of succession, that is rights and duties arising out of state succession, and what are two kinds of state succession and what is state succession. So by this, this is the end of part 1 with respect to the
full text, a full Aiken text of public international law. We will have 3 more parts. We have a total of 41 topics with about 10 topics in each part. So this is the first part from topic 1 to 10 in the Aiken public international law. Thank you for listening. I hope it helps. And if you have any feedback or comments, please drop a message. And if you like the video, just click a like button. If you have not followed my channel yet, please subscribe to my channel to support me and let me know your feedback. Thank you for listening. Have a nice day.